No, my lord, I'll show, my lord.
Sure.
Yes, my lord.
I have a different set, my lord.
If my lord has
No problem. Just tell us the approximate para will be the same. Tell
it's
us.
completely different. We are at C because
No, just tell us your para.
yeah, if my lord will have para 14.9 at
Four-
page 44 of
14.9, is it?
the judgment in review. This is with the review petition, my lord. With the review petition, the main thrust of argument.
Mr. Zoeb, can you give them a copy of the
Yes.
Which page are you?
I am referring to page 44, my lord, para 14.9.
14.9. We'll just see there must be another para which has 14.9 just around that.
Let us see that. Let us see that. No, this paras are different.
Does it go? Yes, the main thrust of the argument.
The argument.
Yeah, just read that, please.
The main thrust of the argument put forth by the Union of India in this appeal is that the amended 2016 Act only clarified the 1988 Act. Law officers appearing for the Union of India trained their guns on the point that the 1988 Act had already created substantial law for criminalizing the offence, and the 2016 amendments were merely clarificatory and procedural to give effect to the 1988 Act. Such a submission mandates us to examine the law of 1988 Act in detail and
It's not a challenge to constitutional validity.
No, my lord,
It's an interpretation.
subsequently, my lord,
No, show us that.
so, my lord will see, this is now dealt, first, section 2A is in para 14.10 along with section 3 is dealt. Then my lord will see, subsequently, the finding.
But the court itself records that it's not challenged. Where is the?
It's not challenge.
No,
It's
not challenged. No arguments are recorded.
Not
No
challenge.
arguments
There
are-
must be a proper discussion on this.
That is the basis.
If you are holding a provision unconstitutional, there must be a proper discussion. Ultimately, you may be right. Yes. You may be able to justify your submissions that it is unconstitutional, but it has to be raised. It has to be argued. It has to be assessed on the basis of rival arguments. We can't just hold a provision to be unconstitutional when there is no constitutional challenge.
What is being subject matter of consideration here was the 2016 Act.
And we are not here. We are not going to say that it is constitutional. You will be entitled to get your full day in court on that to challenge the constitution. We'll hear you on that.
No, my lord, then my lord will give us time to file a detailed reply to this.
No.
To deal with the application.
No, on the merits of the challenge to validity, if it is raised, of course you will. You can.
Of course, my lord. We will need to justify that the judgment deals with all aspects that were considered, my lord.
That can be shown. You don't need an affidavit. Show it from the
It was from the judgment that there was a challenge. The first para says that this is the only issue which is raised. अब ऐसा लिख लीजिए. The review has been sought in these proceedings of the judgment of a three-judge bench of this court in Union of India versus Ganpati D-Com Private Limited, 2023, 1 SCC 315. Full stop. We have in paragraph Mr. Tushar Mehta, learned Solicitor General, or we can just say, the only question which was framed for consideration was in the following terms, paragraph 3 copy kar lijiye. In the conclusion which was arrived at by the court, however, the conclusion which was arrived at by the court was inter alia in the following terms, copied on the whole of para 127. Full stop. From the above conclusion, it is apparent that the court has declared section P2 of the unamended provisions of the Benami Property Transactions Act 1988 as unconstitutional for being manifestly arbitrary and as violative of Article 20(1) of the Constitution. Full stop. The provisions of Section 5 of the unamended Act prior to the amendment of 2016 have been declared to be unconstitutional on the ground that they are manifestly arbitrary. Full stop. After hearing the submissions of the council, it is undisputed that there was no challenge to the constitutional validity of the unamended provisions. Full stop. As a matter of fact, this is clear from the narration, from the formulation of the question which arose for consideration before the bench in paragraph 3 of the judgment, which has been extracted above. Full stop. In this view of the matter, the review would have to be allowed. Full stop. It is straight law that a challenge to the constitutional validity of a statutory provision cannot be adjudicated upon in the absence of a live liz and contest between the parties. Full stop.
And submission.
Likewise, in the present case, we find on the after referring to the submissions which have been recorded in the judgment, that the issue of constitutional validity was not squarely addressed. Full stop. We accordingly allow the review petition and recall the judgment dated 23 August 2022. Full stop. Civil appeal number 5783 of 2022 shall accordingly stand restored to file for fresh adjudication before a bench to be nominated by the Honorable Chief Justice on the administrative side.
Please.
The matters connected to it are all SLPs.
They'll be heard together now.
Those are dismissed SLPs. So to be those.
Dismissed SLPs.
They are not tagged. They are not tagged.
No, they are our SLPs where the high courts have followed this judgment.
We'll all be now heard together.
What was the position at the time in East India?
Many other proceedings have been disposed of by relying upon the judgment of this court in Union of India versus Ganpati Dealcom Private Limited, 2023, 1 SEC 315. My liberty is granted to the liberty is granted to the Union of India to seek a review to the aggrieved party to seek a review in view of the present order.
Replies. Permit to file our reply.
Yes, it's been filed.
Well, possibly your lordships inadvertently dictated 2023 1 SCC. It is 3. Yes. That's immensely great.
One 1501 is that child rights matter, na? Let me just read out the suggestions. No? Where's the learned counsel for the petitioner? Yes. So we have looked at the entire gamut of law on the prohibition of child marriages in India, and we have made a very extensive sociological analysis, and we have given various directions for achieving, the whole purpose of the legislation in India. And I'll just read out only just a couple of paragraphs. In the light of the foregoing analysis, we seek to formulate specific guidelines for achieving the elimination of child marriages, while bearing in mind the delicate socio-economic interplay. Addressing child marriage requires an intersectional approach that acknowledges the overlapping vulnerabilities experienced by children, especially girls from marginalized communities. Intersectionality involves considering factors like gender, caste, socio-economic status, and geography, which often increase the risks of early marriage. Preventive strategies should therefore be tailored to the unique needs of various communities and addressing the root causes of child marriage, such as poverty, gender, inequality, lack of education, and entrenched cultural practices. The PCMA legislation will only succeed through the collective efforts of all stakeholders to address the issue within a broader social framework, which emphasizes the need for multi-sectoral coordination. This necessitates the enhancement of reporting mechanisms, expansion of public awareness campaigns, and investment in the training and capacity building of law enforcement officers and related actors. It is also crucial to regularly monitor the implementation of the Act, conduct evaluations to identify gaps, and establish feedback mechanisms to continually refine and improve responses to child marriage. As we issue these directions, we emphasize the need for more comprehensive approaches and community-driven strategies to ensure the complete eradication of child marriages. We frame the following guidelines for the effective and useful implementation of the PCMA. The orientation of these guidelines is to prioritize prevention before protection and protection before penalization. We are cognizant of the impact that criminalization has on families and communities. To ensure effective use of the penal provisions in the Prevention of Child Marriage Act, it is imperative that there is widespread awareness and education about child marriage and the legal consequences of its commission. We therefore direct that the following guidelines be interpreted to expand effective implementation of the preventive measures under the PCMA analyzed in Part 5A3 of this judgment. We must not be understood to discourage prosecution of those who commit illegal acts. However, the aim of the law enforcement machinery must not be solely focused on increasing prosecutions without making the best efforts to prevent and prohibit child marriage. The focus on penalization reflects a harms-based approach which waits for a harm to occur before taking any steps. This approach has proven to be ineffective at bringing about social change. Then we have guidelines with respect to A, legal enforcement, B, judicial measures, C, community involvement, D, awareness campaigns, E, training and capacity building, F, educational and social support, G, monitoring and accountability, H, technology-driven initiatives for reporting child marriage, and I, funding and resources. Suggestions. In light of the constitutional guarantees accruing to children, we observe certain gaps in the PCMA. Absent a constitutional challenge or a case being argued, we resist from making declarations and restrict ourselves to making suggestions for the scrutiny of the Union. The legal question on these issues, however, is kept open if it were to come before a constitutional court in an appropriate proceeding. The issue of the interface of personal laws with the prohibition of child marriage under the PCMA has been a subject of some confusion. The Union, in its note of submission filed after the judgment was reserved in the case, has stated that this court may direct that the PCMA prevails over personal law. Details of the conflicting opinions were not furnished in the submissions by either party to these proceedings. The PCMA states nothing on the validity of the marriage as we have noted above. The Prohibition of Child Marriage Amending Bill 2021 was introduced in Parliament on 21 December 21. The bill was referred for examination to the department-related Standing Committee on Education, Women, Children, Youth and Sports. The bill sought to amend the PCMA to expressly state the overriding effect of the statute over various personal laws. The issue, therefore, is pending consideration before Parliament. Lastly, we note that while the PCMA seeks to prohibit child marriages, it does not stipulate on betrothals. Marriages fixed in the minority of a child also have the effect of violating the rights to free choice, autonomy, agency, and childhood. It takes away from them their choice of partner and life paths before they mature and form the ability to assert their agency. International law such as CEDAW stipulates against betrothals of minors. Parliament may consider outlawing child betrothals which may be used to evade penalty under the PCMA, while a betrothed child may be protected as a child in need of care and protection under Juvenile Justice Act. The practice also requires targeted remedies for its elimination. A copy of this judgment will be transmitted to the secretaries of all concerned ministries, the Government of India, which includes the Ministry of Home Affairs, Ministry of Women and Child Development, Ministry of Panchayati Raj, Ministry of Education, Ministry of Information and Broadcasting, Ministry of Rural Development, statutory authorities, institutions and organizations under the control of the respective ministries. The Ministry of Women and Child Development is directed to circulate this judgment to the Chief Secretaries, administrators of all states and union territories, as well as NALSA and the National Commission for the Protection of Child Rights for strict compliance with the directions. This shall be done within a period of 4 weeks from the date of delivery of this judgment. The writ petition is accordingly disposed of. We have given very comprehensive directions.
Yes.
So it was very ably argued by the...
And more emphasis on the prevention. Yes.
I'm so grateful, my lords. So grateful.
Thank you. We were wondering where you were because you argued the matter.
Please, my lords.
Mukta, you argued the matter very well and you've given us a lot of very well studied and researched material.
I'm grateful, my lords.
It may be uploaded today itself.
Yes, it will be uploaded right away.
Upload.
It's almost a 140-page judgment where we have considered, all the provisions of the law. Thanks. About a 53-page judgment, very interesting points all of you argued. Conclusion, in view of the discussion above, the appeals filed by ERA against orders of the TDSAT under Section 31 of the ERA Act are held to be maintainable. The registry shall now list the matters before the regular bench for adjudication of the appeals on merits.
So as per the last order, we have filed the compilation and submissions. It can be listed next week, Monday or whenever.
I have that request, my lord. All our compilations and written submissions are before your lordships. If your lordships will consider next week, my lords.
We'll also not take much.
Will not take much time also.
No, we are also no difficulty. But our
How long
questions
will it take actually?
We'll take half an hour on our side. Issues are very...
that may be a little.